Episode 1 on Acme Ghanaian Court Decisions. Welcome to the Law 360 GA channel. Today, we start our journey on bringing to your doorsteps the Acme Ghanaian Court decisions that, to our view, serve as pivotal to the constitutional regime practiced in Ghana today. Our journey on this course shall be in series of episodes, and so let us pay attention to our first episode titled The Discoveries of the Principles from the Topical Martin Pebu Cases. We therefore wish you all the best as you embark on this journey with us. Commencement. Martin Pebu, an Attorney General, on all offences are bailable. Benin JSC. Insofar as Section 96, subsection 7, appears to be a federal clerk on the undisputed constitutional right of the court to grant bail in every offence, it is inconsistent with the Constitution and thus stands repealed, albeit by implication. The court, having endorsed this view, could not at the same time say that Section 96, subsection 7 of Act 30 has rebutted the presumption of innocence. At worst, they would be contradictory in terms, in which case the more beneficial one to the right of the accused person or in favor of personal liberty should prevail. The principle of presumption of innocence is a very important one in the criminal justice system, and it underpins the basic concepts of individual liberty under the Constitution. The locus classicus of the principle of presumption of innocence was the case of Coffin in the United States, and his lordship referred to that part of the judgment as the principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law. The UN Declaration of Human Rights, Article 11, Clause 1 states that everyone charged with a penal offense has the right to be presumed innocent until proved guilty according to the law in a public trial, at which he has had all the guarantees necessary for his defense. The same principle is restated by Article 7, Clause 1b of the African Charter on Human and People's Rights. Article 19, Clause 2c of the Constitution reaffirms this principle, which Ghana has subscribed to at both the UN and AU. The grant of bail is one of the tools available to the court to ensure that a suspect or an accused, as the case may be, is guaranteed his innocence until the court has found him guilty. The presumption of innocence embodies freedom from arbitrary detention and also serves as a safeguard against punishment before conviction. It also acts as a preventive measure against the state from successfully employing its vast resources to cause greater damage to a person who has not been convicted than he can inflict on the community. Therefore, in my humble view, any legislation outside the Constitution that takes away or purports to take away either expressly or by necessary implication the right of an accused to be considered for bail would have prejudged or presumed him guilty even before the court has said so. That would be clearly contrary to this constitutional provision, which guarantees his innocence until otherwise declared by a court of competent jurisdiction. In my opinion, besides Article 14, Clause 3 and 4, which the court in the Goman case endorsed as having impliedly repealed Section 96, subsection 7 of Act 30 Supra, the said statutory provision is also contrary to the letter and spirit of Article 19, Clause 2c, insofar as prohibition of the right to apply for cost consideration for bail presumes the guilt and not the innocence of the suspect or accused, as the case may be. It is necessary to state that the issue whether to deprive a person of his personal liberty under Article 14 of the Constitution is not a magisterial or executive act, but a judicial one, to be performed under the Constitution. Benin JSC upheld the words of Justice Frank Murphy in his dissenting opinion in the case of Oklahoma Press Publishing Company and Walling that liberty is too priceless to be forfeited through the zeal of an administrative agent. Indeed, any law that violates any of the Chapter 5 rights under the Constitution is itself unconstitutional. Article 15, Clause 2 of the 1992 Constitution gives protection to the person who is under some form of detention following an arrest. The provision ensures that his human dignity is not abused by the sort of punishment that is inflicted upon him, or the way and manner his detention is effectuated by the state. That is where all state actors have a role to play at every turn in the criminal justice system to ensure that a complainant's dignity as a person is not abused. The ends of justice should not lead to chaotic results or absurd situations. That surely is contrary to the constitutional provision and even international human rights instrument which allow the prosecution and possible imprisonment of persons who fall foul of the criminal laws. In my view, The provision of Article 15 Clause 2 is invoked where the plaintiff complains that the legislation in question has prescribed some form of punishment that is cruel, degrading, or inhuman, which is consequently inconsistent with this constitutional provision. Secondly, the provision applies if there is a complaint that a particular legislation has prescribed some form of detention, which is a violation of his human dignity. In either case, it will be within the plaintiff's right to have such legislation declared unconstitutional. Applications for bail in serious offenses should be taken as a serious business in the interest of society, which has adopted a constitution impliedly removing the restrictions imposed by Section 96, subsection 7 of Act 30, and placing the trust in the court that all the competing interests would be taken care of. Would CJ, as she then was. One of the cardinal features of constitutional democracies governed by the rule of law is the power of judicial review. It is a strong bulwark against illegality and impunity and insulates citizens against their human rights violations. Dr. Ateba JSC, in the case of Adolfo and Attorney General, as referred by Wood CJ in this case, said that the power of judicial review of the constitutionality of legislation, which is explicitly conferred on this court by Articles 2 Clause 1 and 130 Clause 1 of the Constitution, is one that should vigilantly be enforced by this court in the discharge of its obligations to uphold the Constitution of this country. The Constitution expects judges to protect individuals and minorities from the power of the majority. The provisions on the fundamental human rights and freedoms enshrined in Chapter 5 of the 1992 Constitution are intended to facilitate the fulfillment of judges of this expectation. In courtroom litigation, it is not counsel's mere spirited views nor propositions that informs a court's decision one way or the other. Otherwise, court work would be in perpetual jeopardy. Judges would be rendered judicially impotent and ineffectual without the ability to pronounce on any dispute, giving parties to competing interests and divergent opinions that are invariably advanced in support of their respective positions. Classically, counsels or a party's significantly different views on any given matter only assist the court to comprehend their respective claims and identify the law and fact in issue, but certainly their assertions, opinions, theories, or arguments are not a determinant for either identifying the real issues or judging the matter. Constitutional human rights and freedoms provisions are entitled to the most benevolent and liberal construction on account of their very essence, entrenched constitutional laws pertaining to fundamental rights and freedoms. Thus, a narrow and restrictive interpretation in a manner that fails to advance individuals' rights and liberties is not permissible. Given our Article 14 in a sui generis construction, it is to be noted that bail, not being an inalienable right, Article 14 Clause 4 does not confer on a person arrested, restricted, or detained under Paragraph A or B of Clause 3 of Article 14 an automatic absolute right to bail in all cases and under all circumstances. But neither does it provide for the complete opposite, namely an automatic denial of bail. Automatic does not, in my view, imply that the court's decision on whether bail must be denied or granted is mechanically triggered upon the mere production of a charge sheet, as the case may be, with a stated bailable or non-bailable offense, even if the same were a trumped-up charge or plainly if the facts do not support the charge. An equally significant statutory interpretation principle requires that laws that curtail rights and freedoms must not be construed expansively or liberally, but narrowly and restrictively. Per Dr. JSC. From the Seydu and Republic case, Dr. JSC added, the following principles must guide the court having jurisdiction to consider bail application in serious cases, such as indictable offenses or offenses tried summarily. 1. Whether the accused would appear to stand for his trial. 2. The nature of the evidence in support of the charge or offense against the accused. 3. Closely linked to the above is the nature of the accusation. And 4. The severity of the punishment which the conviction will entail. Where the facts in a charge do not support the offense charged, the accused is entitled to bail even in non-bailable offenses. Dr. JSC further affirmed Justice V.C.R.A.C. Krabbe Understanding Statutes book, where he listed the following as factors a court of law must look for when construing an act of parliament. A. A court of law will not be astute to find out ways in which to defeat the object of the act. B. A court of law will not only look at the language of the preamble or of any particular section, but at the language of the whole act. C. A court will look at the context, the collocation, and the object of the words relating to the matter in hand in order to interpret the meaning of the words according to what would appear to be the meaning intended to be conveyed by the use of the words. D. A court of law would not admit the principle that abstract justice would require or justify a departure from the established rule of construction. E. A court of law will not, in the treatment of two consecutive subsections in an act, isolate one from the other and give effect to each without regard to the other, unless it is absolutely necessary. Ad inhera JSC, the presumption of innocence, sometimes referred to by the Latin expression ei incumbe probatio judici, non qui negat. The burden of proof is on the one who declares, not on the one who denies. Is the principle that one is considered innocent unless proven guilty. It is thus a due process requirement that the prosecution proves the charge against the accused beyond reasonable doubt. The doctrine is therefore more appropriately relevant in determining the evidential burden on accused persons in criminal trial. NB. The dissenting opinion of the court in the case above were ad inhera and bedebe JJSC, as they then were. Key vocabularies to take out of the case. 1. Per with CJ. Dissentient. Ratiocination on the principal issue. Contrariwise. Epoch-making decision. Buoyed. Sequitur. Undergirding. Extant. Furthered. A trumped-up charge. Full panoply. Juridical synergy. Phraseology. Watershed. 2. Per JSC. Belabor. Ex escaribus actus. Carte blanche. See above principles from the case for more. Martin Pebble, an Attorney General, on the alteration of Section 42G of Act 29, and then the subsequent affirmation on the current law on an essential element for proving the crime of conspiracy. Akamba JSC, as he then was. What is meant by the two expressions, adaptation and amendment? Adaptation, as defined by the Oxford English Dictionary, has a plurality of meanings and applications, most of which allude to the process of changing to suit an alternative purpose, function, or an environment, the alteration of one thing to suit another. The Oxford Modern English Dictionary, edited by Julius Swanell, 1999 reprint, defines the verb adapt to mean adjust one thing to another, make suitable for a purpose, alter, or modify, especially a test. The same dictionary defines amend as v. Make minor improvement in a test or written proposal. Correct an error or errors in a document. Make better, improve. Where the meaning of the words used is plain and obvious, there is no need to resort to any other aids of interpretation, unless the resort to that would be at variance with the intention of the lawmakers or lead to some absurdity, as his lordship Akamba JSC, as he then was, relied on Urban JSC, as he then was, in Ghana Bar Association and Attorney General, where he stated thus, "It must be borne in mind that, in construing any statute, for that matter any of the provisions of the Constitution, the first duty of the court is to stick to the ordinary meaning of the actual words used. After ascertaining the general purport and meaning of the provision in question from the words used, effect must be given to it, unless by so doing it would be at variance with the intention of the lawmakers, or could result in or lead to some obvious absurdity." Black's Law Dictionary, 8th edition, by Brian A. Garner, defines discretion to mean individual judgment, the power of free decision-making. So discretion is also defined as an individual's power to make decisions without anyone else's advice or consent. The Oxford Modern English Dictionary, edited by Julius Swanell, also defines discretion to mean the freedom to act or think as one wishes, usually within legal limits. To borrow the words of Francois JSC in Kinnear and Archer, rules of construction do not permit a passage which has clear meaning to be complicated or obfuscated by any interpolation, however well-intentioned. The Commissioner acted within the powers conferred by Section 3 of the Enabling Statute under Act 562 of 1992, could not be faulted in his election. provided also that the Commissioner exercised his discretion fairly and candidly in accordance with Article 296 of the Constitution 1992. He was within his powers to determine whether or not to resort to the process of introducing a bill in Parliament or any alteration or amendment. The opportunity came when Parliament, which granted the Commissioner the power to undertake the revision exercise, was presented with the concluded works. Significantly, Parliament did not complain about any of the matters presented to them, including the amendment of Section 42G of Act 29, 1960, albeit en masse, gleefully approved them pursuant to Section 8 of Act 562, 1998, and Article 106 of the Constitution 1992. Thus, the omission or deletion of marital consent as a defense for the use of force in Section 42G of the Criminal Offences Act 1960, Act 29, having 12 been adopted pursuant to the approval of Parliament, even if considered an alteration or amendment of substance, cannot be attributed to the Commissioner but to Parliament. The law aids the vigilant, not those who sleep, vigilantibus et non demiantibus during surveillance. Kamba JSC, in concluding, referred to the words of the champion of the philosophy of judicial self-restraint, Justice Frank Feather, in his dissenting opinion in the case of Trapp and Dallas cited in part by Pega JSC in Ghana Bar Association and Attorney General as follows. Rigorous observance of the difference between limits of power and wise exercise of power, between questions of authority and questions of prudence, requires the most alert appreciation of this decisive but subtle relationship of two concepts that too easily coalesce. No less does it require a disciplined will to adhere to the difference. It is not easy to stand aloof and allow want of wisdom to prevail, to disregard one's own strongly held view of what is wise in the conduct of affairs. But it is not the business of this court to pronounce policy. It must observe a fastidious regard for limitations on its own power, and this precludes the court giving effect to its own notions of what is right or politic. That self-restraint is the essence in the observance of the judicial oath, for the Constitution has not authorized the judges to sit in judgment on the wisdom of what Congress and executive branch do. There is no doubt from our analysis of events above that this court's decision in the unreported case of Ekene Anoze and the Republic, which expresses a contrary position, was given per incurium. Hence, we would depart therefrom. Pursuant to Article 129, Clause 3 of the Constitution. In the Ekene Anoze case supra, we utterly fail to consider whether the changes resulting from the Commissioner's adaptation or amendment on the law on conspiracy fell within the mandate granted him and thereby fell into the error of merely upholding the decision of the Court of Appeal without due consideration and thus endorsing the impression that the Commissioner's amendments were void. In this vein, the decision of the High Court Accra Quorum, Mafusau J.A. as he then was, sitting as an additional High Court judge in the case of Republic and Augustine Abu, which acquitted the accused person on 2 counts of conspiracy to commit robbery, was correct. The High Court reasoned that the new formulation by the Commissioner had changed the old law on conspiracy, such that proof of prior agreement to act together with a common purpose is now a new and necessary ingredient that must be proved by the prosecution, failing which the charge must fail. This is a correct position of the law on conspiracy, as it accords with our conclusion that the Commissioner's 7 volumes of the Laws of Ghana, revised edition, having received the necessary parliamentary approval and adoption, every statement of the law therein contained is the correct position thereof, unless pronounced otherwise. Before I am finally done, my Lady Chief Justice, presiding, my Lord and Lady, this being my ultimate judgment on the bench after almost 40 years of service, indulge me one more time to take the liberty to wish for the bench and bar in particular the continued support and cooperation necessary for nurturing our nascent democracy to the highest level deserving of the people of Ghana in integrity, competence, efficiency, and effectively. It is for this confidence that the people of Ghana have entrusted to the judiciary the power to administer justice on their behalf. The very success of our democracy depends upon a strong, competent, and impartial judiciary, which has been the case over the years and must be sustained. The bar has this duty, being officers of the court, to always work for the success of this confidence and to sustain the symbiotic relation to each other. Martin Pebble, an Attorney General, on the 48 hours rule and court setting during weekends and holidays. Akufo, CJ. The substantive two issues for resolution were A. Whether or not upon a true and proper interpretation of Article 14, Clause 3 of the Constitution, the unavailability of judicial and court services to persons under arrest or in detention on suspicion of criminal conduct on public holidays, weekends, or during events of civil unrest is in consonance with or is in contravention of the Constitution, and B. Whether or not upon a true and proper interpretation of the Constitution, the trial of the accused persons who are in pre-trial detention must take precedence over trials of persons who have been admitted to bail. The first issue raises other questions. A. What is the intent and purpose of Article 14, Clause 3? B. What should be the method of reckoning the 48 hours time limit set by the article? C. Are there any circumstances that would justify an exception without contravening the Constitution? Article 14, Clause 3 forms part of Chapter 5 of the Constitution, which deals with the fundamental human rights and freedoms. The centrality of these rights and freedoms in our jurisprudence cannot be gainsaid in any way, as confirmed by Article 290, which includes the entirety of the said chapter among the entrenched provisions of the Constitution. It cannot be amended except by a national referendum of at 40% of eligible voters on a bill to amend a specified provision, and must be passed by 75% of such voters. It is also significant to note that these rights, which are enshrined in our Constitution, are derived from an internationally acknowledged normative framework for the protection of human rights that harks back to the United Nations Universal Declaration of Human Rights, 1948. This instrument, for the first time, enunciated a body of rights and freedoms that reflect the ethos of multicultural origins, common to the very basic concept of being human. Numerous treaties, conventions, charters, and protocols have evolved and continue to evolve from the grounding principles set out in this declaration intended to strengthen and better protect specific groups, children, women, the youth, the aged, refugees, etc., or groups of rights. These formal legal norms include the International Covenant on Civil and Political Rights 1966, the African Charter on Human and People's Rights 1986, and the African Charter on the Rights and Welfare of the Child 1990, coming into force in 1999. All these instruments uphold and reinforce the principle that there are certain rights which are fundamental and inherent in the very fact of being human. They are not granted by any political or royal act. They are universal and adhere to every human being, wherever he or she is, and of whatever gender, religion, or social status. Included in these inherent rights are the right to life, the right to personal liberty, the right to hold opinions and religious beliefs of one's choice, etc. All such rights are subject to respect for the rights of others and to the laws that are necessary for assurance of a just and peaceful society in which rights may be enjoyed equitably. It is in this spirit that we have in our Constitution Article 14, Clause 3, which protects the right to personal liberty by requiring that even where such rights are curtailed by lawful means, the custodian is obliged to bring the arrested or detained person before a court of law within 48 hours of arrest or detention, or release the person conditionally or unconditionally. This is clearly the intent and purpose of Article 14, Clause 3. When a person arrested or detained is brought before a court of law within the 48 hours, the court is afforded the opportunity to make timely determination in some issues concerning personal liberty arising therefrom, so as to prevent the infraction or continued infraction of such rights, because, in the final analysis, it is only the decree of a court of competent jurisdiction that carries power to deprive a person of his or her liberty for a longer period than that stipulated by the Constitution. The language of Article 14, Clause 3 is clear and unambiguous, and, in our view, within 48 hours means exactly that. The decision in Bernard Moyner and Attorney General, 2013 to 2014, SCGL Special Edition 502, that the courts cannot be expected to sit on statutory public holidays, could only represent the general position, as the court in the said case was not called upon to enforce Article 14, Clause 3 of the Constitution. That provision never formed part of the core matter before the court, and the decision cannot amount to a precedent of any relevance to the matter herein. It is, therefore, irrelevant to, or at best distinguishable from, the determination of this case. Consequently, it becomes clear that a specific exemption ought to have been made under Section 4 of Act 601 for the sittings of the court on public holidays to determine issues concerning personal liberty. Indeed, and all the better, the determination of whether or not a court should sit on a public holiday should have been accepted from Act 601 and properly left to the discretion of the Chief Justice. To the extent that Section 4 of Act 601 has the tendency to bar or effectively bars the court from sitting on public holidays to determine issues of personal liberty, pursuant to the right enshrined in Article 14, Clause 3, the section, as it now stands, is unconstitutional. In order to make Section 4 of Act 601 compliant with Article 14, Clause 3 of the Constitution, this court hereby exercises its power of rectification and exempts court services by the addition to the exemption list in subsection 3 after paragraph K the following. L. Court services for the determination of issues concerning the personal liberty of any person. We declare further that any right guaranteed under a statute regarding weekly rest periods for preference starting from Saturday and ending on the Sunday following are subservient to the rights enshrined under Article 14, Clause 3 of the Constitution. In the same vein, to the extent that subsection 3 of Section 35 of Act 651 and Order 79, Rule 2, Subrule 3 of CI 47 bar the courts from sitting on public holidays and weekends to determine issues of personal liberty under Article 14, Clause 3, the subsection and the rule are unconstitutional. Section 35, subsection 3 of Act 651 is hereby rectified by the addition to the exemption list after paragraph B the following. C. Regarding court services for the determination of issues concerning the personal liberty of any person. Order 79, Rule 3, Subrule 2 of CI 47 is hereby rectified by the insertion of the following after Chief Justice. The constitutional expectation rule is that a person must not lose his or her liberty for more than 48 hours unless that person has been brought to a magistrate or a judge and the issue of his or her personal liberty has been determined. The interest being protected under Article 14, Clause 3 of the Constitution must override all other considerations such as pre-existing statutory right, inconvenience, any attendance, administrative cost, etc. Additionally, it is essential that every unit of the police service of Ghana be aware of the need to comply with the spirit of Article 14, Clause 3b, which empowers the police to release an arrested person. Our understanding of this is that, having arrested a person, where there is nothing that compels the police to hold on to that person, and suddenly, where there is no possibility of that person being brought before a court within the 48 hours, he or she ought to be released. Thus, as a cogent example, if a person is arrested and detained or restrained by the police in the evening of Monday, Thursday, there can be no justification to hold him or her until the Tuesday after Easter Monday. The police have the power and ought to release the person on whatever reasonable condition or conditions, such as that he or she reports daily to the unit and appears in court the first working day or any such date as they would determine. The expression within 48 hours in Article 14, Clause 3 of the Constitution includes all days, public holidays, weekends, periods of strike action, or civil unrest, subject to the reasonable assurance of the safety and security of judicial officers and service staff. Court services must be available on the aforementioned days to determine issues pertaining to personal liberty in due compliance with Article 14, Clause 3 of the Constitution. And B. At the latter part of the judgment, Her Ladyship outlined some specific administrative tasks for the enforcement of the judgment above, and such administrative measures outlined targets both the courts and the police service. Key vocabularies: gainsaid, hearts, ethos of multicultural origins. This is where we will end our episode 1 on Acme Ghanaian court decisions worth noticing. We humbly seek you all to write down your comment to help us feed you better. And please, do not forget to subscribe to this channel to join the community. Like this video, share the link to all, and feel free to contact us via email, thelaw360gh@gmail.com. Thank you, and enjoy the rest of your stay with us. The Law 360 GH channel, solemn oneness to imbibe the law.